In the middle of June 1215, in a field called Runnymede on the River Thames near Windsor, a great charter, or Magna Carta, was sealed by King John in the presence of his own armed supporters and a much larger group of men who had been rebelling against his rule. The sealing of the Great Charter was the culmination of a process that had started the previous November in the Temple Church in London. A process that took place with a background of civil war and which appears to have been largely guided by Stephen Langton, the Archbishop of Canterbury, and by William Marshall, who is named in the Charter as the first of the King's advisers. That document was the first of 4 successive charters, which were sealed over the next 10 years. They differ in a number of respects, but all seek to define the rights of the King's subjects and to limit and control the King's power. They followed a practice of English kings going back to before the Norman Conquest, of confirming to their subjects the rights and liberties which they could be allowed to enjoy. On the death of King John in 1216, William Marshall was appointed guardian of the boy king Henry III, and ensured that a form of the charter was sealed in the new king's name. The charter was again confirmed by Henry III's successor, Edward I, in 1297, when the charter was entered as a statute of England and Wales, and by subsequent monarchs up to the 14th century. As well as the fundamental provisions contained in Article 29, the charters covered a huge and diverse range of issues, from the extent of the royal forests to the rights of widows, from a limitation of what we would regard as taxes to sittings of the law courts, from promotion of commerce to the dismissal of a number of named officers of the King. Even at the time, the potency of this document was understood and had an influence beyond England and Wales. Copies were distributed throughout the country. Copies were translated and sent to Ireland. The extraordinary power of restraint on the monarch contained in Clause 61 of the original text caused great alarm in Rome and the courts of Europe, and indeed that clause was removed from subsequent charters. However, it wasn't long before the rights of the charter were being quoted in the law courts and in correspondence. Although subsequent monarchs could be to a greater or lesser extent absolutist, indeed tyrannical, in their government of the country, the Great Charter represented the first significant check and balance in our constitution, establishing the primacy of the law as opposed to arbitrary executive action.